Hello, my name is Amber Rouse Holloway. I'm a partner here at Secrets Wardle and Troy, and I'm here to discuss the use of statutory immunity in defending amusement and leisure-focused claims, such as ski areas, roller skating centers, bowling alleys, and horse stables. Of note, the majority of today's presentation will discuss the Ski Area Safety Act. There is an acronym for the Ski Area Safety Act. It's called SASA. SASA. So throughout today's webinar, you'll hear me say SASA. So just keep note of that. This presentation today will discuss the definition and scope of the Ski Area Safety Act, the immunity provision in the Act and its application to hazards identified, the applicability of immunity to hazards not identified in the statute, application of immunity to chairlift injuries, the trouble with tubes, as tubes are not covered within the Act, the use of waivers, and I will briefly discuss the use of statutory immunity in defending roller skating centers, bowling alleys, and horse stables. Today I wanted to discuss several definitions that will help lay the foundation for today's webinar. An operator means a person who owns or controls or who has operational responsibility for a ski area or ski lift. An operator includes the state or political subdivision of this state. Ski area means an area used for skiing and served by one or more ski lifts. Of note, ski area also includes areas that are used in snowboarding. It does not include areas that are used for tubing, as I discussed earlier. And last but not least, skier means a person who is wearing skis or utilizing a device that attaches to at least 1 foot or the lower torso for the purpose of sliding on a scope. Included in the definition of skier is also a snowboarder. Skier also includes a person not wearing skis or a skiing device while that person is in a ski area for the purposes of skiing. An example of that is a parent that is in the ski area assisting a child putting on skis, and then after assisting the child has the intention on putting on skis themselves. Some important notes from the definition section. A ski area must contain a ski lift to qualify as a ski area. As I stated earlier, the definition of skier does include snowboarders. And anyone riding on a lift or tow rope is also a participant under the Act. In order to be a participant under the Act, a ski area must also comply with minimum safety requirements to earn this protection and immunity of the Act. Under MCL 408, Section 342, subsection 1, while in a ski area, each skier must do all of the following: maintain control of his or her speed at all times, stay clear of snow grooming vehicles and equipment in the ski area, heed all posted signs and warnings, and ski only in ski areas which are marked for open skiing on the trail sign. SASA expressly identifies a scope of hazards. However, there are some that are not identified. We will discuss the ones that are not expressly identified in the statute a little bit later. However, under the statute, each person who participates in a sport of skiing accepts the dangers that adhere in that sport insofar as the dangers are obvious and necessary. Those dangers include, but are not limited to, injuries which can result from variations in terrain, surface or subsurface snow or ice conditions, bare spots, rocks, trees, and other forms of natural growth or debris, collisions with the ski lift towers and their components, with other skiers, or with properly marked or plainly visible snowmaking or snow grooming equipment. So those are the hazards that are expressly identified in the statute, MCL 408, Section 342, subsection 2. So what happens when something identified in the statute is not being used for the purpose it's intended and actually causes an injury? The Act essentially codifies the classic common law assumption of the risk defense. Numerous cases have tested the scope of the risk skiers assume for claims against ski areas and fellow skiers. Courts have enforced the Act broadly. Generally speaking, a skier or snowboarder who hurts himself in a ski area while skiing or snowboarding cannot hold the ski area liable for any hazard identified in the Act. What happens, though, when something is not set forth in the act? In that situation, that's normally when the courts get involved and thus case law is generated. A case that discusses what happens when something is not specifically identified in the act is McGoldrick v. Holiday Amusements. In McGoldrick, the hazard was identified in the statute. However, it wasn't being used for the purpose of skiing as required by the act. In McGoldrick, plaintiff struck a pole that was used for a chairlift while skiing. A chairlift was identified in the statute. However, by the skier running into the pole, it wasn't being used for the purpose of skiing. Because the chairlift was identified in the act, the court granted immunity, and the case was dismissed by way of summary disposition. There's also an issue of a hazard that is not expressly identified in the statute. So in the McGoldrick case, the hazard was identified, but the purpose was not identified, or the purpose was not used specifically as the act intended. However, there's also this issue of the hazard not being identified in the act whatsoever. And that's where the Anderson case comes in at. Anderson v. Pine is a 2003 case which created the immunity provision. In the Anderson case, the court created two elements. Is the hazard inherent in the sport of skiing, and is the hazard obvious and necessary to the sport? As we briefly discussed in the McGoldrick case, the SASA grants broad immunity to ski areas involving the use of chairlifts. And with this being said, it's important to note two things. Chairlifts can also include tow ropes, and the immunity provision is also in effect for claims of an act of negligence on the part of the chairlift operator. In the case of Kent v. Alpine Valley Ski Area, the court held that plaintiff's experts pointed to no factual evidence to establish statutory violations by defendants that could affect the otherwise unrestricted immunity for operators when a skier collides with a chairlift. The court did have generalized opinions that the use of a stop button or a slow button should be used on any lift carrying children. All right, the trouble with tubes. As I stated earlier, tubing is not covered by the Ski Area Safety Act. So, because snow tubing is not covered by SASA, what can a ski area do to protect itself from potential litigation that may arise from a tubing injury? It is my opinion that the best way to attempt to protect the ski area would be to use signage and waivers. The use of waivers to address liability. The case of Paterick v. 6600 LTD discusses waivers. Essentially, the thing about waivers is that they are valid in Michigan, and Michigan courts have upheld them, especially for adults. It should be noted that waivers are not valid as to children, and the court has also failed to uphold any instances of an adult signing a waiver on behalf of their minor child. And that is the case of Woodman v. Cara. Indeed, Michigan courts have proven to be particularly cautious when it comes to permitting the compromise of any child's rights, and thus far has strictly adhered to the common law preclusion of parental authority in signing those waivers. Nevertheless, it would still be recommended that a parent sign the waiver for the child, as it may deter litigation. There's numerous case law, such as the Woodman case, where the waiver was not upheld. It may be persuasive to a jury. I also wanted to briefly discuss the use of statutory immunity in defending roller skating centers and horse stables. The Roller Skating Safety Act of 1988 is often referred to as RSSA. The act codifies the statutory defense available in potential claims for injuries arising out of roller skating centers. Under MCL 445, Section 721, immunity is provided for the roller skating center for dangers arising out of, but not limited to, injuries that arise from collisions with other roller skaters or other spectators, injuries that result from falls, and injuries which involve objects or artificial structures properly within the travel of the roller skater, which are not otherwise attributable to the operator's breach of his or her common law duties. Similarly to SASA, by participating in the sport of roller skating, a participant assumes the risk of injury from obvious and necessary dangers inherent to the sport of roller skating. The Roller Skating Act does not extend to ice skating rinks, golf courses, swim clubs, or tennis clubs. It should be noted that the legislator has also codified a premises owner immunity from litigation for bowling centers and horse stables under the Michigan Bowling Center Act and the Equine Liability Act. And back to SASA. There are some questions as to if the Ski Area Safety Act immunity provision is ever going to be dismissed or appealed, and it's my opinion that it seems to be a live and well-settled law. In the unpublished opinion of Marshall v. Boyne, there was a snowboarder involved in a terrain park. That snowboarder had been doing tricks earlier in the day and then went into the half pipe. Later on in the day, he came back to that same half pipe and was injured. The snowboarder made a claim that the half pipe was not visible and therefore the Ski Area Safety Act immunity did not apply. The court upheld the immunity for the ski area. It seems as if the court is going to keep this trend of upholding the immunity going as long as the ski area follows the signage and licensure requirements that are outlined in the Act. Further notes on the Marshall v. Boyne case, the court reasoned that it agreed with the defendant that SASA barred the plaintiff's claim. Under SASA, a skier assumes the risk for those dangers that inhere in the sport of skiing unless those dangers are unnecessary or not obvious. That was also true for bowling centers or horse stables. Among those risks in SASA are variations in terrain. Although the plaintiff argued that defendant breached the duty not imposed by the statute to mark that half pipe itself, the Anderson test made it clear that when SASA resolves a matter, common law principles are no longer a consideration. By choosing to ski in the terrain park, which was marked with signage as required by SASA, which contained the half pipe that plaintiff saw earlier that day, plaintiff accepted and assumed that danger. Some takeaways from today's presentation. A ski area must make reasonable efforts to maintain the safety of that area. The use of statutory immunity should be used to defend ski area claims and is often used. And a defendant must utilize directed discovery to the plaintiff. Also, a defendant must ensure plaintiff can prove that there was no signage by using requests for admissions. SASA also applies to snowboards and chairlifts, but not tubing. And even though not upheld by Michigan courts, a ski area should still get a waiver signed by an adult and children, even though the waiver signed by the child are not valid. Thank you for attending Amusement and Leisure Land. The use of statutory immunity in defending amusement and leisure-focused claims, such as ski areas, roller skating centers, bowling alleys, and horse stables. Again, this is Amber Rouse Holloway, a partner here at our Troy office. Please feel free to contact me with any comments or questions you may have.